Many people don't know that disturbing one's peace can be an act of domestic violence or domestic abuse, punishable by law, warranting a restraining order, and can cause mental, emotional, physical, as well as spiritual distress. As pointed out previously, domestic violence does not have to have a component of physical abuse or sexual abuse in order for it to be deemed domestic violence. Now, each state differs in how it defines domestic violence as well as the components of domestic violence. However, more knowledge is being gained and laws are being applied towards a broader definition of domestic violence other than physical abuse and sexual assault. This does include disturbing one's peace. And here's an example. One case concerns the marriage of Nad Carney. The parties were in the process of separating when the husband accessed the wife's emails without her permission and distributed them. This case occurred in California. The appellate court found the trial court erred in failing to find abuse sufficient to warrant an order under the DVPA, which is Domestic Violence Protection Act. The appellate court confirmed that there need not be a showing of physical injury or assault, but that several types of nonviolent conduct constitute abuse. The Nat Carney decision confirmed that contacting the other party, either directly or indirectly by mail or otherwise, may constitute abuse. The court also defined the plain meaning of the phrase disturbing the peace of the other party as conduct that destroys the mental or emotional calm of the party. And in the case of Nat Carney, the court specifically found that the husband's actions destroyed the mental or emotional calm of his former wife by accessing, reading, and publicly disclosing her confidential emails. In Burkett versus Brumbaugh, an ex-boyfriend continued to contact and harass his ex-girlfriend after being clearly told she no longer wanted contact. The court upheld the definition of disturbing the peace as defined in Nat Carney and applied it to the context of a non-marital relationship in which the abuse consisted of a nonviolent but unwanted course of conduct of contacting the plaintiff by phone, email, and text, and showing up uninvited and causing a scene. The appellate court confirmed the trial court's decision that the actions disturb the peace of the other party. Such a disturbance of the plaintiff's peace in the present case constitutes an act of abuse under the DVPA. And in the most recent case of Evel Cesar versus Sweeney in 2015, an appellate court affirmed that physical abuse is not necessary to warrant a restraining order and that disclosing the personal details of someone's life can constitute abuse. Furthermore, the appellate court affirmed the trial court's finding that the disclosure of various communications can constitute disturbing the peace of the other party within the meaning of the domestic violence statute. And further, this finding of abuse is made acknowledging that there was no history of physical abuse. Those above three cases recognize that abuse does not necessarily always come in physical form. Nonviolent behaviors can be just as abusive, harassing, and damaging within the context of domestic violence. Now, it may not be simple for the court to make a ruling of disturbing one's peace in the context of domestic violence. But if you feel that your peace has been disturbed, your mental, emotional, physical, or spiritual peace has been disturbed and it's causing you distress, maybe it's causing fear, it's causing you not to be able to sleep, anxiety, then by all means, utilize the resources that you have available. Take it before the court if you need to for an order of protection and get the help that you need. I'll leave you with the following passage. Numbers 6, 24 through 26. The Lord bless thee and keep thee. The Lord make his face shine upon thee and be gracious unto thee. The Lord lift up his countenance upon thee and give thee peace. Thank you so much. God bless you, and stay tuned for the next topic on emotional abuse.